Okay, go ahead.
Awesome. Good morning, everyone. This is part two of this series that Adrian Slater and myself will be conducting between this week and next week. Um, as I mentioned to you yesterday, my name is Roberto Chavez. I'm a real estate attorney in El Paso, Texas. I've been practicing for a little over 6 years, and so the topic for this week is force majeure clause. Uh, and it really became something that people were talking a lot about these last couple of months when the pandemic started. Force majeure used to be just a small clause there hidden at the end of leases that people really didn't pay attention to, but given the current circumstances, it's come to the forefront of a lot of conversations and a lot of legal arguments and so on. And so I think it's important that we discuss it because moving forward, um, especially, it'll be very important for anybody signing a lease, whether they're on the landlord side or on the tenant side, to be very mindful of this clause and make sure that it protects you whether you're the landlord or the tenant. And so with that, we can go ahead and start. So, what is force majeure? That's the first question, and so it's a French word that translates to superior force, and it's defined as an event or effect that can be neither anticipated nor controlled, an unexpected event that prevents someone from doing or completing something that he or she had agreed or officially planned to do. The term includes both acts of nature, such as floods, hurricanes, earthquakes, and acts of people, such as riots, strikes, and wars. So, what about this clause? So, historically, it embodied the notion that parties, in this case, landlords and tenants, could be relieved of performing their contractual duties when performance was prevented by causes beyond their control. So, looking at this general definition of force majeure, it would seem like the current pandemic COVID-19, would fall under the definition. But as we'll kind of discuss this provision in more detail, you'll see that that's not necessarily the case. So it's very important that when we talk about force majeure, we understand that force majeure comes into play only if and when it's included in your lease or your contract. And so it's not just some random idea or remedy that somebody can grab onto. It's something that has to be in your lease or your contract for you to be able to take advantage of it. And so if you're the tenant, you want to make sure you have it in there and you have specific language that benefits you so that you can take advantage of the force majeure clause. And if you're the landlord, well, on the one end, if you don't want the tenant to have that protection, you probably don't want it in your lease. Or if you do, you want to make it specific as to certain things or certain things that you agree to. So that's the first thing. The first thing is to look at the force majeure clause in your contract to see if there is one. Um, as it pertains to COVID-19, as everybody now knows, the World Health Organization has officially declared COVID-19 to be a pandemic, and all U.S. agencies have declared COVID-19 to be a pandemic. And so if your force majeure clause specifically states a pandemic or an epidemic, excusing you from performing what you need to do under your lease or your contract, then that COVID-19 would probably be an excuse for performance under the lease. Um, as you can imagine, there's a wide variety of force majeure clauses. So it might not necessarily talk about a pandemic or an epidemic, but it might talk about government regulations or changes in the law, such as the stay at home or shelter in place orders, that if any of those come into effect, then at that point you don't have to comply with your lease. And so again, this is just to reiterate that it's important for you to read your lease, review it, and make sure that the clause is there and that it protects you. Um, So again, this is to reiterate that it needs to be in your contract, and you need to make sure that it's there, because the scope and application of the doctrine of force majeure will depend on the terms of the contract. And so for the past, what is it now, 5, 6 months, I've been reading a lot of force majeure clauses, and I've been looking at so many of them. And interestingly enough, the majority of them, not all of them, but the majority of them, most leases are prepared by landlords and signed off by tenants. And so the majority of the leases have a force majeure clause that specifically states that the tenant doesn't have to perform his or her duties under the contract if there's a force majeure event, but it specifically excludes the payment of rent. And so what the landlords have historically done, and maybe not purposefully, but maybe it's just a form that they grab, or just a standard pro landlord force majeure clause, is that it specifically stipulates that the tenant doesn't have to perform certain obligations of the lease if there's a force majeure event. However, in the event of a force majeure event, nothing will excuse a tenant from not paying rent. In other words, even if there's a pandemic, COVID-19, whatever it is, the tenant has to pay rent, which pretty much, I mean, it negates the purpose of force majeure for a tenant. But again, it's a contractual doctrine. And so if the parties contractually agree to that, then that's what the parties agreed to, and so they have to abide by that. So that's just what I've seen in the last couple of months. And so if you're a landlord, that's great. If you're a tenant, you want to make sure that you're protected against that, and that you negotiate something there that will state something different. And so we had a lot of both tenants and landlords come to us and say, hey, from the landlord's perspective, tenant is not paying rent. Can I evict them? Can I lock them out? Can I do all of these things? Well, for a short period of time there, as you may be aware, there was a moratorium on evictions. And so landlords weren't allowed to evict tenants, both on the residential and the commercial side. At least I know that to be the case in El Paso County. I don't know in other counties in the state, but so they weren't allowed to do that. But at the same time, we had tenants calling us and saying, hey, I can't open my business. People can't come into my restaurant. People can't buy whatever I'm selling. I can't pay the rent. Can I get out? And so the first um, review, or the first approach, would be to see if there's a force majeure clause, see specifically what it says, see if the tenant is excused or not. And so that was the first approach. But then we had to get a little bit more creative and start to see other remedies to see if maybe there was another way for the tenant to get out. And so recently we've researched these other remedies, and we're going to talk about them in a little bit more detail. But they're impracticability, quiet enjoyment, and impossibility. And so in most of these cases, there wasn't a force majeure out for the tenant. And so we had to do a little bit of research to see, okay, we don't have an out on the contract specifically, but is there something out there that um, that will relieve you from performing your responsibilities that's not specifically in your contract, but you have access to because of the current situation? And so The first one we researched was impracticability. And so there's three elements to being able to resort to this remedy of impracticability. The first one is that an unforeseeable event has occurred. COVID-19 would presumably be an unforeseeable event. Hard for anybody to argue that they saw that coming. Non-occurrence of the event was a basic assumption on which the contract was made. That could also be an argument. I mean, non-occurrence of a pandemic was an assumption, and you being allowed to open your restaurant or your shop to customer was a basic assumption. And then the party seeking discharge of their responsibilities is not at fault. And so here you're talking about the tenant who's seeking to be discharged from their responsibilities under the lease, and clearly they're not at fault. They're not at fault because of the pandemic, and they're not at fault because the county is telling people to shut down. And so at first glimpse, we thought that maybe if a landlord were to sue the tenant, we may be able to defend them under the principle of impracticability. However, economic impracticability is not a recognized defense in Texas. The Texas courts have held contractual obligations cannot be avoided simply because the obligors, being the tenant's performance, has become more economically burdensome than anticipated. And so even though the elements are pretty much met given the current situation, traditionally, Texas courts have held that economic burdensome is not an excuse. However, and I'll kind of run you through the process, this was all before COVID-19 and before the pandemic. And so none of the cases that we found had a tenant claiming that in a worldwide pandemic or something of that nature made it impracticable for them to perform their lease. And so it's difficult to say whether if today somebody went to court and argued this defense, that a judge would say, no, too bad, Texas courts don't recognize economic impracticability as a defense. Things have changed. In the scenario where we researched this, the tenant and the landlord came to an agreement, so it never went beyond the research. And so as of today, I haven't found anything that's recent enough that talks about COVID-19 and economic impracticability. But I don't doubt that those cases might be coming up in the future. And I would suspect that there's going to be some different rulings based just on the nature of what we're living through. And so that gives me some hope for tenants to be able to have an out. The problem with this out is that it requires litigation, and it requires most of the times the tenant to have to pay attorneys to defend them. And so, and that takes some time. That's why we haven't seen any new cases that reflect this this doctrine. But I think there is hope for tenants with this doctrine of impracticability. But again, it hasn't really been tested, so we'll have to wait and see how Texas courts react to this kind of defense. Hopefully, some tenants do take advantage of it in the future. So that's, let me see, somebody's coming in. We'll admit them. Okay. So that's the kind of pre-pandemic rulings in Texas. And we really haven't seen the post-pandemic rulings, but if I were a guessing man and based on what I've seen and read, I think it's going to be a little bit different, but we'll have to wait and see. So that's impracticability. The next one is quiet enjoyment. So I mean, depending on your specific situation, 99.9% of leases state that the landlord, as long as the tenant is paying rent and doing what they need to do, the landlord will allow the tenant quiet enjoyment of the property. And so for there to be a breach of quiet enjoyment, and again, the tenant to be able to say, hey, I'm not enjoying my property, these four elements have to be complied with. And so the first one is an intention of the landlord that the tenant no longer enjoy the premises. So right off the bat, it might be a little difficult if the excuse is COVID-19 to say that the landlord was the one that intentionally not allowed the tenant to enjoy the premises. It's a material act by the landlord that substantially interferes with the intended use and enjoyment of the premises. The act permanently deprives the tenant of the use and enjoyment of the premises, and the tenant abandons the premises within a reasonable time after the commission of the act. In order for there to be a breach of the covenant of quiet enjoyment, the landlord himself must be the one responsible for the act, or been the one to direct it, for the lessee or the tenant to have lost their enjoyment of the property. And so the reason we researched this one a little bit more is because this is the one that tenants are most familiar with. And so they were bringing it up and they were asking us, well, look, we're one of the premises of me leasing this property is that I was going to be able to enjoy the property, but now I'm being told that I can't go to my property and I can't open it up for business and I can't have customers here. I mean, I can't enjoy the property anymore. And so why would I have to pay for it? It's a breach of the contract. It's not quiet enjoyment of the property, and therefore I should be able to get out. Um, well, we did the research, and for that one to be applicable, it really has to be the landlord, the one who does something to interfere with the tenant's enjoyment of the property. Otherwise, it's really not something that a tenant can use as a defense for non-payment of rent and then subsequent lawsuit if that were to happen. So we've talked about impracticability, quiet enjoyment, and then the next one is the common law doctrine of impossibility. And maybe before we jump into this one, I wanted to see if maybe there were any questions on the previous points that we discussed. I don't know if anybody wants to put a question on the comments or anything like that. Feel free to do that. I also wanted, and I should have said this from the beginning, but I guess now that we have more people here, today's presentation is force majeure, and that specific clause in contracts that really has become a talking point in recent months because of the pandemic. But the purpose of these webinars are for your benefit, and if there's something specific that you would like to ask me or that you would like to discuss, I'm more than happy to discuss something that's outside of force majeure. At the end of the day, I mean, this is for y'all's benefit, and so if we didn't touch on something or any of these things kind of trigger a thought or a question, we're more than happy to talk about them. And so I just wanted to mention that this is an open forum, and happy to talk about any other legal issues that you might have. But getting back to impossibility, so we researched impracticability, quiet enjoyment, and then impossibility. So the common law doctrine of impossibility of performance is that impossibility of performance occurring after the contract is made is not an excuse for non-performance if the impossibility might have reasonably been anticipated and guarded in the contract. And so, and I'll go ahead and read the second part. When a party voluntarily undertakes and by contract binds himself to do an act or thing without qualification, and performance thereof becomes impossible by some contingency which should have been anticipated and provided against in the contract, the non-performance will not be excused. In such case, the party's failure to exempt himself from responsibility in the event of the happening of the contingency will be attributable to his own folly, and he will be held to make good his contract. Um, so this one was probably the most, I guess the best word would be consequential that we researched, because clearly, if you signed a contract or a lease of some sort before March or February or April, it's really impossible for somebody to have anticipated and or guarded against a pandemic happening in the next couple of months. And so impossibility really comes into play for those contracts that were signed before the pandemic. If you sign a contract today or anytime moving forward and don't address a possible pandemic or a possible closure of businesses, then that'll be interpreted as you negotiating with the understanding that that was a possibility, but you just decided not to include it in your contract. And so impossibility really comes into play for contracts before the pandemic. We think this is another common law doctrine that tenants may take advantage of for contracts signed before the pandemic, but we really don't think people are going to be able to make the argument of impossibility of performance post pandemic, or contracts signed post pandemic. And so this one again, um, we did the research, um, we studied it a bit, but we really haven't tried to enforce it or use it in court. It's one of those situations where the landlord and the tenant came to an agreement, but I mean, just to have the the ability to have these kinds of conversations with your landlord, assuming you're a tenant, already gives you a hand up in the negotiation, because I mean, at least you tell them, look, I've got these weapons, and if we go to court, there's a good chance I might win and might be able to defend myself. And so let's negotiate something. It's much better than going into the negotiation room saying, hey, I can't make rent. Can you just help me out? And not really have anything to back up your negotiation. Um, I do want to say that we also found that some courts in Texas have construed that if you already have a force majeure clause in your contract, then you can't invoke the principle of impossibility. Um, it's seen as a way that you already negotiated for that, as I previously mentioned. And so if you have a force majeure clause, then you thought about these kinds of events that could have happened, but you decided not to specifically put it in your contract. And so if you don't have a force majeure clause in your contract, then you have a better chance of making the impossibility argument and being successful at that. Um, yeah, and the other comment was that this is more of a pre-virus defense. There's no doubt that if something else in the future happens that we couldn't have anticipated or guarded against, that prevents you from performing your responsibilities, that this doctrine might apply. But the whole point here is, if there's another wave that causes closures, that causes the government to tell stores and restaurants to shut down, uh, you won't be able to make this claim if you sign the contract post COVID-19 or this pandemic. Um, okay. So I also wanted to give you something a little bit more practicable. Where is it? Here we go. I wanted to show you what we've been doing for tenant clients. As you can imagine, for landlord clients, it's been completely different. But what we've been working on is to include some language in these leases that protect the tenant. And so this is just an example of a force majeure clause. It means neither party will be liable for any failure or delay in performing an obligation under this agreement that is due to any of the following causes.
Roberto?
Oh, yes.
Okay, sorry, your audio is going in and out.
Oh, my bad. I don't know. Hold on. Let me check my. Looks okay. Can you hear me better now?
Yes, that's perfect. Thank you.
Okay. Yeah, no problem. Let me know if that happens again. Apologize for that. So, as I was saying, neither party will be liable for any failure or delay in the performance of an obligation under this agreement that is due to any of the following causes. And of course, those causes have to be beyond their reasonable control. It's acts of God, accidents, riots, war, terrorist acts, epidemic, pandemic, quarantine, civil commotion, breakdown of communication facilities, breakdown of web hosts, breakdown of internet service provider, natural catastrophes, governmental acts or omission, changes in laws or regulations, national strike, fire, explosion, etc. And so, again, this is a completely negotiable uh, clause in your contract. So I'm not sure how much of this you'll be able to get in, how much the landlord's going to push back. Um, it really depends on whether the landlord wants you in that space more than you want to be in the space. But it's just it's it doesn't hurt to ask for everything and then just maybe scale back a little bit. I can tell you off the bat, as I mentioned at the beginning of the presentation, the majority of the clauses, the force majeure clauses, will have language, even maybe word by word like this, but then at the end of of the clause, it'll have another sentence that says, notwithstanding anything contained in this provision, uh, nothing will excuse the tenant from paying rent to the landlord, something to that effect. In other words, even if there's a terrorist attack or there's a war or there's a riot, nothing will excuse the tenant from paying rent. And so it's important for you to make sure that that's not in there, and if it is, you know that it's there, so that way it doesn't catch you by surprise. um, Other techniques that I have encountered, and this is just from recent experience, is agreeing up front to a rent reduction by X percentage or X number of dollars in the event of another pandemic. And so the last one that I worked on, that the tenant and the landlord agreed to, was if there was another um, pandemic, or no, that specific one said if the tenant was required to close their doors, not allowed to operate during normal business hours, then the tenant would be excused from paying rent throughout the time that the that they couldn't open. And that rent, let's say they weren't allowed to open August, September, October, that rent, it would be divided by the next 12 months, and they would have to pay it during the next 12 months. So in that case, I mean, it wasn't the best deal, but at least they're not going to be in default if they don't pay their rent while they're closed. They'll have to pay it at a later time. But I've seen cases where they're agreeing to excuse maybe half of the rent, and so half of the rent is forgiven, and the other half you have to pay it throughout the rest of the term of the lease. And so all that, I mean, it just depends on your specific situation and how you want to address it. But I mean, that all that is to say that at least when you're in the process of executing your lease, you can get very creative, and you can think of, and you can work out different ways to make sure that you're protected in the event of something like this happening again. And so you want to make sure that before you sign the lease, you make sure you have in it whatever it is that you feel comfortable with, and that the landlord has agreed to. Um, and so that I know it's a little bit early. I wanted to leave some time for some Q&A. That really completes the analysis of the force majeure. Next week, we're going to get a little bit into more detail on the different provisions in your contract that you should try to negotiate, and where I see that tenants have more headaches, not only during the pandemic, but even pandemic aside, just clauses and provisions that tenants should be on the lookout for. And so do you guys have any questions? I mean, I'd like to leave it open for Q&A at this time, if anybody has any questions or comments about any part of this presentation, or anything else that might have been triggered by the presentation. Oh, we've got some.
And if so, please go ahead and if it's easier, just unmute yourself and then ask the question.
Hi, Roberto, this is Adrian.
Yeah, Adrian.
For the tenants out there, you know, you had mentioned at the outset that you know the purpose of the force majeure, one of the purposes is to help with rent relief um, uh, during these times of you know, pandemics and acts of God and things of that nature. Are you seeing landlords change their mentality and be more willing to allow um, temporary waivers of rental payments during times of force majeure? What are you seeing in terms of real life practice over the last 6 to 9 months since we've had to deal with COVID-19? Thanks for
Yeah, the vast majority of the landlord clients that we have been extremely open to some sort of agreement. The last thing they want right now, I think that the climate is one where landlords are unsure whether they're going to be able to rent out their space very easily, or at their current rental rates that they've got right now. So the majority of them, we have helped them pursue conversations with tenants where we tell the tenant, look, we're not going to evict you, but we need some form of payment plan. And that's been the general consensus of most landlords that we work with. They want to have, sure, don't pay me these next 2 months, but maybe pay them at the end. But let's get something in writing where you agree that starting in November, you're going to start paying rent. And then one landlord actually said, look, I won't charge them for June, July, August, September, like 4 months. I'll give them for free, but let's sign an extension of their lease. So it expires in 2 years. Let's extend it for another 2 years or 3 years. And so they're thinking of creative ways of working with tenants, because what I've seen, the last thing they want is to incur fees in evicting somebody. One, because it's going to cost them money, and two, they're going to have an empty space that I don't know how confident they are that they're going to be able to lease it out to somebody quite as easily as they have in the past. And so they're very, very amenable. The advice here is reach out, have a conversation, whether you're the landlord or the tenant, before you move forward with any kind of legal action, because I think there's a lot of room for negotiation, whether on the landlord side or on the tenant side, but much more on the tenant side is what I've seen.
Thank you.
Thank you, Roberto.
Sure.
Does anybody else have any other questions, or Adrian, do you have anything else to add to that?
No, I didn't. I thought if you like, we could just talk a little bit about what we'll be discussing next week's seminar.
Yeah, that works.
So session 2 next week on Tuesday. What we'll be talking about, we'll get into a little bit more of the strategies that small business owners can use when negotiating new leases, renewal leases, rent and abatement agreements. We're going to focus on the important tenant clauses and negotiating leases during COVID-19, including termination options, exit strategies, and force majeure, the abatement clauses, improvement investment clauses, renewal opportunities, and information about health and safety considerations regulated by governmental agencies. So those are some of the things that we'll talk about on Tuesday. And I thought I'd just give everybody a brief overview of that discussion that will happen. Thank you.
And I'll piggyback on that. It'll be very similar to what Adrian just explained, but more on the legal aspect of it. Renewal terms, rent abatement, insurance provisions to be on the lookout for. Just a variety of specific provisions in your typical lease that you want to be aware of. You want to negotiate. You want to make sure, even if you don't get a satisfactory negotiation out of it, at least you know then and be aware of those things, so that if any issues come up in the future, you're better prepared. And so we'll get into more detail of those next week.
Perfect. Thank you so much, guys. For everybody else, I did drop the link into the chat box. When you have a moment, please take our survey. I will also follow up with an email in case those that arrived a little bit late need the recording to today's session. I'll be sure to provide that. And Roberto, will you be able to provide us the PowerPoint so that I may share with the attendees?
Of course, I'll send it to you here shortly.
Okay, perfect. If anybody doesn't have any more questions for today, we're going to go ahead and end today's session, and we will see you all back next week on Tuesday. And I hope everybody has a great weekend. Thank you so much, guys.
Thank you.
Thank you. Have a good day.
Bye. You too. Bye.